Good morning, and good afternoon, good evening to everyone, wherever you are. Welcome to this side event on the sidelines of the 49th session of the Human Rights Council. My name is Letta Taylor, and I'm an Associate Crisis and Conflict Director at Human Rights Watch. I'll be co-moderating our hour-long session with Simon Crowther, a legal advisor at Amnesty International. Simon and I thank the International Commission of Jurists and Article 19 for joining Amnesty and Human Rights Watch in organizing this event. We also thank the mandate of the UN Special Rapporteur on Human Rights and Countering Terrorism for their collaboration. A couple of housekeeping items before we begin. This event is being recorded. We also hope very much to have time for questions toward the end of our discussion. Please type any questions for panelists in the Q&A field. We can unmute you and show you on video if you prefer to pose your questions verbally. We meet today on the virtual sidelines of the Human Rights Council session on the need for an international campaign to close the US military detention center at Guantanamo Bay, Cuba. For those of you who may not be familiar with what's happened at Guantanamo over the past 2 decades, the US has unlawfully held at least 780 Muslim males at Guantanamo since it brought the first 20 men to the base, shackled and blindfolded 2 decades ago. 15 of the detainees were children. 38 of these men remain today. Most have not been charged. None has been fairly prosecuted. Many detainees have been subjected to torture and other physical or mental abuse, some at CIA black sites abroad, others at Guantanamo itself, or both. President Biden has promised to close Guantanamo, but as we speak, his administration is building another courthouse there. He's only transferred 2 men out of the prison so far. With the US having rejoined the Human Rights Council this year, the time is right for an international campaign to close one of the most enduring symbols of abuses in the so-called global war on terror. I now hand the floor to Simon, who will introduce our truly impressive list of panelists and lead the next portion of our event. Simon, over to you.
I'd like to echo all that Letta has just said. Guantanamo has been a blight on the US's human rights record for far too long and is a problem the world needs to address. So we have today a truly impressive group of speakers who will help us understand why member states should join a campaign to end detention at Guantanamo Bay. One of them is Mahamadou al-Slahi, who was held at Guantanamo for 14 years without charge or trial. Mahamadou is now a best-selling author and the subject of a Hollywood movie, but his achievements come at a price that no one should ever have to pay. And we particularly thank Mahamadou for joining us today. We'll also hear from human rights lawyer Alka Pradhan, who represents Ammar al-Baluchi, one of 5 men at Guantanamo accused of involvement in the September the 11th attacks. Alka will share details of Mr. Baluchi's torture at the hands of the CIA and walk us through what passes as justice at Guantanamo. Alka is actually joining us from Guantanamo today via video link. And Shivan Sarin is Deputy Director at Reprieve US, and he'll help us understand what happens to men once they're freed and released from Guantanamo. But to lay the groundwork for their comments, we'll start off with 2 formidable independent human rights experts who've worked closely on violations at Guantanamo. Elina Steinert is the is the chair rapporteur, of the UN Working Group on Arbitrary Detention, and Fionnuala Ní Ioláin is the UN Special Rapporteur on Human Rights while Countering Terrorism, whose report to this Human Rights Council session details the harms stemming from Guantanamo. So I'll start by turning to you, Fionnuala. Let's set the stage. You chose secret detention, unlawful rendition, and detention practices as the subject of your thematic report to the Human Rights Council, which you'll be presenting on Tuesday. To many, the challenges at Guantanamo appear to be a distinctly American problem. Why should the international community care?
Thank you, Simon. Thank you all for being here. So my report on secret detention, I think, builds on the sustained and deep engagement of UN special procedures on the issue of secret detention and is a specific follow-up to the 2010 Joint Special Procedures study, which found that secret detention, rendition, arbitrary detention practices occur on every continent with long and sustained histories. These practices, to state the obvious, undermine the rule of law and ultimately make us all less safe and less secure. But in the contemporary context, the continued function of a detention site in Guantanamo Bay, Cuba, poses enormous legal and political quandaries. As the dilemma imposed by Gitmo has passed essentially from administration to administration, and the number of detainees have dwindled, as you say, it might seem like this is no longer a major problem. And yet, I think we have to resist the temptation that speaks about moving forward. It may appear to be less relevant or less politically palatable to address these issues of serious violations in the past, and there's often a tendency to avoid the kind of confrontation that it requires to address Guantanamo head-on. The reality is that 38 men remain straddled, detained, and it's our collective duty to address each of these individual cases, these detainee cases, with humanity, with dignity, and with respect. We can't just patch over, just move on, as it were, over the massive consequences of the human rights violations that have occurred at Gitmo. Nor, frankly, is it in anyone's national security interest to do so. Guantanamo Bay, Cuba continues to represent a globally recognized symbol of torture and unlawful detention. And it's the normalization of these practices by the world's most powerful states that actually is the challenge, the fundamental challenge to the rule of law. The full repudiation of these practices requires us drawing a straight line from the past to the present. And as Special Rapporteur, I draw a direct line between the practices that led to arbitrary detention at Guantanamo Bay, Cuba, to the torture that accompanied that incarceration, with the contemporary practices of mass detention accompanied by sustained allegations of torture, inhuman and degrading treatments, particularly in other cases. And those two cases highlighted in my report are the situation in Xinjiang and the situation in Northeast Syria, because both of these places illustrate the ongoing ways in which essentially there's a tolerance and acceptance of arbitrary detention at scale, and a perceived notion that there's actually no cost for states for engaging in those kinds of practices. So that's all to say, Simon, when you ask if this is still relevant, is that unlawful mass detention remains a truly global and immediate challenge. And I look forward to discussing with my co-panelists what concrete actions we can take to close Guantanamo, but also what it would look like to apply those lessons in the very present of mass detention in multiple sites.
Thank you, Fionnuala, and that's a really key point, isn't it? That this is something that undermines the rule of law globally and makes us all less safe. Alina, if I could turn to you now, let's now focus in on Guantanamo. The vast majority of the roughly 780 detainees who were held at Guantanamo were never charged with a crime. Many were held for years. The few who have been convicted were prosecuted at fundamentally flawed procedures in so-called military commissions. Does this amount to arbitrary detention? And if so, in what ways?
Thank you, Simon. Good afternoon, everyone. On behalf of the Working Group on Arbitrary Detention, thank you very much for having me here. Let me start with the fundamental principle that is at stake here at the heart of the question that you just posed, and that is the principle of personal liberty. International human rights law is absolutely clear. Everyone is entitled to the right to personal liberty, which can be legitimately curtailed only in certain exceptional circumstances. And of course, such exceptions can be, for example, when an individual is accused of a crime and is therefore detained and taken into custody. This decision to detain an individual lies at the hands of a state, of the authorities of that state. And to ensure that this right is not abused, does not lead to arbitrary detention, the international law has placed a string of safeguards. Because let us not forget, prohibition of arbitrary detention in international law is absolute. There are no reasons that can justify it. There are no circumstances that can legitimize it. International law does not permit derogations from Article 9 of the International Covenant on Civil and Political Rights, neither do the regional human rights treaties, which also codify the absolute prohibition of arbitrary deprivation of liberty. Now, turning to the jurisprudence of the working group on detention in Guantanamo, which regrettably stands and strings along quite a few years. What the working group throughout these years has firstly examined is the very nature of this detention. The working group on numerous occasions has been presented with the argument that this, in fact, is administrative detention that takes place in Guantanamo. However, upon the examination of the circumstances, all suggests to the working group, and the conclusion of the working group is that this, in fact, is criminal detention in nature. Individuals held there were and are subjected to investigations against over various alleged acts, commission of such acts. Sometimes there were suggestions of charges, but in the end, no official charging had taken place, no presentation before the court, no subsequent legal proceedings to establish in the court of law whether a person indeed is guilty of a particular crime or not. And all this has amounted to a string of human rights violations, the right to be informed of charges, of reasons for arrest at the time of arrest, the right to be informed promptly of the charges, official charges thereafter, the right to challenge the legality of detention before a judicial authority, which is fundamental prerequisite for legal deprivation of liberty, and to do so with effective legal representation, effective legal assistance. All this has been absent in Guantanamo detention cases. And in the view of the working group, all this amounts to detention without legal basis being properly established and is therefore arbitrary deprivation of liberty. Furthermore, most of individuals spent years and years, even decades in Guantanamo with no indication when, if ever, they will be brought to a trial. This is a manifest violation of fair trial requirements, which also leads to arbitrary deprivation of liberty. These individuals have been denied effective legal assistance and full access to evidence against them, which are further essential preconditions of fair trial. Additionally, cases brought to the working group reveal the most appalling treatment that these individuals have been subjected to, which the working group has concluded amounts to torture. Noting that this was inflicted with the aim of extracting confessions, it also amounts to a further violation of fair trial rights and thus contributes further to arbitrary detention. The working group has also examined the reviews carried out by the military commissions and review boards and found that these, as non-judicial bodies, lack the requisite degree of impartiality and independence as required by Article 14 of the International Covenant on Civil and Political Rights, and therefore cannot satisfy the requirements of this provision, which further contributes to arbitrary detention. And finally, through the years of jurisprudence concerning detainees in Guantanamo, the working group has observed a pattern, a very sad pattern. All these individuals are foreign nationals and belong to Muslim faith. This has led the working group to conclude that the persons concerned have been detained on discriminatory basis, which also is arbitrary in international law. Therefore, to sum up in the answer to your questions, the detentions in Guantanamo lack legal basis. They do not satisfy the fair trial requirements and guarantees, and they are discriminatory. And therefore, in the view of the working group, they constitute arbitrary deprivation of liberty. I'll stop here.
Thank you. And there's a very many interesting points made there, but one in particular is the nature of arbitrary detention and how some UN special procedures bodies have determined that the ongoing conditions in Guantanamo actually reach the threshold of torture and cruel, inhumane and degrading treatment under international law. And of course, that really very key point there about discrimination and the fact that this is only a form of detention that is being used against people of Muslim faith. I'd like to turn now to you, Alka. You've served as counsel for Ammar al-Baluchi for a number of years now. What are the conditions your client has been held in? And can you tell us about the struggles that tortured detainees face receiving adequate healthcare at Guantanamo?
Of course, thank you. And again, thank you to all the panelists for including me in this. If you hear construction at any point behind me, it's because I'm actually standing right at the point where Camp Justice is being expanded, Camp Justice. And so they're building more homes, they're building a second courtroom, and they're doing it all right over here, earlier than I anticipated. But so I have represented Ammar al-Baluchi for more than 6 years now, and I have watched in horror as he has deteriorated in front of me during that time. He is only 45 years old. During 3.5 years at CIA black sites, he was subjected to mock drownings, putting a wooden bar behind his knees and making him kneel, forced nudity in freezing temperatures, and smashing his head over and over again against a wall, which gave him a traumatic brain injury. More than that, they used music and 24/7 fluorescent lights to deprive him of sleep for 3 years continuously out of that 3.5 years. And of course, he was being held incommunicado without access to family or lawyers that entire time. Dr. Mitchell, one of the so-called architects of the CIA torture program, testified that interrogators would use visual or other psychological cues to remind the men that torture could start again at any point. So the psychological impact was devastating. Ammar, like many other tortured detainees, has been diagnosed with a host of physical and psychological illnesses caused by his torture, PTSD, traumatic brain injury, cognitive decline now. And even after he and the other black site detainees arrived at Guantanamo, they lived in a CIA facility here, Camp 7, for 15 years until last year. And so the psychological stress is crippling. And that's not even accounting for the illnesses that come from aging in a sort of decrepit, isolated detention camp. The problem is that the US government refuses to provide tortured men like Ammar with proper medical care for their torture, the sort of holistic care that is mandated by the Convention Against Torture. The medical staff down here are not allowed to take medical histories of the men because that would require recognition of their torture. And it's nearly impossible to get specialized tests done. It took 7 years of requests and litigation to actually just get MRIs done for the men down here. So they are now literally and psychologically falling apart. We're getting so desperate, honestly, that just yesterday we actually filed a motion to compel a mixed medical commission for Ammar under a regulation that regulates a panel of medical experts to determine whether he should be transferred for medical care. Torture experts all agree that rehabilitation cannot be provided in a detention setting, much less by the people who inflicted the torture, the party that inflicted it. And so our hope is that the Biden administration recognizes the ongoing medical crisis down here that is of our own making, and at a minimum starts finding places to provide proper care for these men, since we cannot do it here.
Thank you, Elke. I mean, that is truly a shocking human cost, and it's so important that we don't forget that that is a shocking ongoing human cost of having this base open. On that point, could I turn now to you, Mohamedou? You spent 14 years at Guantanamo Bay before being released without ever being charged with any crime. Can you share with us what your experiences were like?
Simon, thank you so much for inviting me. I just love listening to these experts. And for those who don't know me, who just joined, my name is Mohamedou al-Salahi. I was kidnapped and I spent a little bit over 15 years between secret prison in Jordan, in Afghanistan, and a little bit over 14 years alone in Guantanamo Bay. So I remember vividly the day the Mukhabarat secret police came to our home. It was Ramadan 4th, November 20th of 2001. And so they came to me, they were in plain clothes, and I just came back from work around 4 p.m. So they came and they told me to come along with them. And I was afraid, of course, but the fear that I could see in my mother's eyes is something that's so intense that I never experienced in my life. It would take me so many years to have my own son to understand, how painful to have your son taken away from you, and there is nothing you can do. So those are not police in a democratic country where they show you cause and they tell you arrest you in the name of the law, and this is why. And of course, every mother wouldn't like her son to be arrested, but still you have a fighting chance. You know where your son is. Not with my mother. I was taken away and they told me to drive my own car. And then one of them sat beside me and the other was in the other car. And I could see my mother in the rear view mirror as she slowly was getting smaller and smaller. And after about 200 meters, I turned right and she disappeared. Absolutely, And what I didn't know then, I would never see my mother again. It would take so many years. And I was informed in 2013 that my mother passed away. And the pain was so intense that I couldn't really, it was like a burning sensation inside my heart. So I had to punish my body in order to equalize my spirit with my body. And I stood and I started to pray, reciting the Quran. And I think after 6 hours, I was so exhausted because I was pacing around. And then, and then I collapsed. And then I came back. Again, I recited the rest in all 600 pages. And as if this is not enough, they came to me again. They said, your brother also passed away. I was subjected to this so-called enhanced interrogation technique. And when I see Atka there in front of Camp Justice, this is actually the place where I used to be dragged between the interrogation room. So on the other side, we have brown building, yellow building. On the other side, there was a gold building. I vividly remember when Lieutenant Zuli came to me and he said he was going to take my mother, kidnap my mother. What he didn't know, after 70 days of torture, he thought I was resisting, but I didn't have any feeling anymore. It's not resistance or anything, but I didn't have any feeling. Then when he said that he was going to kidnap my mother and put her in men-only facility, it was like electric jolt. So I was say, okay, I will say anything, I will sign anything. And I signed this horrific confession that I was involved in some fantastical terror attack, and I was the first death penalty detained. And this all collapsed when they put me on lie detector, because the lie detector completely cleared me of everything. And then they couldn't release me anymore because now I was a witness. That's why I had to struggle so much. And just want to make one last point, that when we are released from Guantanamo Bay, the tragedy is not going to end. I was deprived from talking. I was deprived from having my own paper to travel. Now I'm sitting, alhamdulillah, thank God, in Cambridge because of the fight of people like you, Amnesty International, Human Rights Watch, the lawyer, good people in the UN who keep, driving this issue of human rights. And I need to stop here. Thank you so much.
Thank you so much, Mohamedou. It really is an honor to have you with us here today, because it's so good to be able to hear, well, good may not be the right word, but it's so important that we hear the first-hand account of just how terrible the toll of Guantanamo is. Shivan, towards the end of his address there, Mohamedou mentioned his experience of being released. Now, many Guantanamo detainees now were repatriated, but more than 140 were actually resettled in about 30 third countries. And this was in an effort to prevent them from being tortured or subjected to other cruel, inhumane, or degrading treatment in their countries of origin. Since one of the only ways to close Guantanamo is to transfer men held there to their homes or to third countries, what can you tell us about this process, and has it been successful? And if so, what has worked best and what hasn't?
Yeah, thank you so much to everyone for joining and for the words. I'll start on the process. So like so much in Guantanamo, the process is shrouded in secrecy, and as several panelists have already discussed, is extrajudicial. So what we know is that 6 federal agencies approve the individual for transfer. And at that point, the US government begins to negotiate transfer agreements with third countries in the resettlement context. It's critical to know that only after those agreements are signed does the individual get transferred. But neither the men nor the lawyers ever receive the documents and understand their rights in the country post-transfer. And that's also critical to understand because these men oftentimes have never been to the country that they're being transferred and have never lived there either. So it's particularly challenging to not know what the subject of their transfer is at that point. And then the last point on the process is, unlike the Obama administration, this US administration has not appointed a special envoy for Guantanamo closure. So that creates even more difficulty in understanding what the process is around transfers currently. Second, on what we've seen has worked best. So we've worked to support several men who have been resettled rather than repatriated. And there are kind of 3 tenets that we see that ensure a supportive transition. So those are safety, security, and sustainability. So on safety, those are guarantees that the individual will be free and have basic human rights to not be extrajudicially detained, tortured, disappeared, and at times executed. And all of those things have happened through transfers and resettlements. On the security piece, it's providing the individual with a secure and long-term status. And that allows the individual to actually see themselves in the community, embed themselves in the community, and be able to access basic services to be able to transition and live sustainably. That kind of feeds into the sustainability point. It's critical for countries to provide straightforward support and rehabilitation services. And those can include housing, a monthly stipend to cover living expenditure, medical support, torture rehabilitation, family reunification, access to vocational training. All of these things help an individual to be able to truly embed into a community that they, as I mentioned, they've never been to. And the final point here is that it's critical these conversations begin pre-release and continue throughout the transfer and afterwards. In states that have provided these basic necessities and protections, we see men really thrive and integrate within the community. We see them start businesses, start families, make a whole new life for themselves after their brutal detention at Guantanamo.
Thank you, Shivan. That's some really key points there about the circumvention of justice systems, which is something that is pervasive throughout the whole of the Guantanamo system, it feels. And of course, the importance of a holistic approach to resettlement of people who really, at this stage, sadly have quite complex needs. On that note, I'd like to pass over to my colleague Letta to conduct the second round of questions. Thank you.
Thank you so much, Simon. And thank you, panelists, particularly Mohamedou, but all of you for your comments. Elena, I'd like to start off with you, just to switch the order around a little bit. In a report to the Human Rights Council last October, the working group that you chair, the Working Group on Arbitrary Detention, expressed several concerns about treatment of men who've been transferred from Guantanamo to the United Arab Emirates for resettlement. We heard just now some of the concerns about ways that resettlement, some of the concerns that we should be having on resettlement. When Siobhan spoke, what can you tell us? What were the concerns that you outlined in your report? Thank you.
Thank you very much. First of all, just a point of clarification. I believe you are referring to the opinion published by the Working Group, opinion number 32 of 2021, which is an individual communication which the Working Group received. This is a sort of a peculiar procedural element here that I would like to highlight. The Working Group is the only of the UN special procedures which can receive individual communications, allegations of arbitrary deprivation of liberty, which then engages this, what we call regular communications procedure, and leads finally to the adoption of the opinion of the Working Group as to whether the particular facts, allegations which are brought to the attention of the Working Group reveal an instance of arbitrary deprivation of liberty. This is also in my previous answer when I gave sort of a summary of Working Group's jurisprudence that primarily dealt with the opinions of the Working Group on arbitrary detention concerning specific individual cases of persons who have been detained in Guantanamo. So when you talk of the report, I believe your reference is made to this particular opinion. So far, the Working Group has received and considered only a few cases concerning the third country resettlement of persons held in Guantanamo. Aside from this opinion 32 of 2021, we also had opinion of 85 of 2019, which concerned the resettlement issues in Guantanamo. And I would also like to highlight here specifically that the Working Group does not solicit any cases. It is a matter of free choice of anyone who wishes to bring a case to the attention of the Working Group. We do not go out and seek them out there. So the fact of how many we have them should not be used as a kind of a detriment, as a kind of a determination of the scale of issue one way or another. However, among these two cases, what we see as a, if I may say so, concerning common thread in these cases is the chasm between the prior alleged arrangements regarding the resettlement to which the individuals in question agreed and what transpired in reality on the ground when these individuals were actually transferred. This is exactly the point that Siobhan was making just a few minutes ago. The individuals usually don't receive the copies of the resettlement arrangements and have no idea of what to expect. According to the information received, however, by the Working Group, the individuals were usually told that they would have a normal life after a period of rehabilitation of usually around 6 months, a normal life with employment, a modest income, the ability to live freely in the society, to see their families. In reality, the cases that have come before the Working Group document de facto continuation of the conditions and many instances also treatment that the persons received in Guantanamo. Individuals are transferred to what is termed rehabilitation, which is in de facto a prison facility with virtually no contact with the outside world, with no clear indication, no prospect of release. The resettlement arrangements, as Siobhan already mentioned, are under a veil of secrecy. There is no monitoring whether the sides adhere to what has been agreed. And so in these two cases on the issue that have so far reached the Working Group has found that these individuals continue to be arbitrarily detained in these countries of settlement. So to answer your question, the key concerns, the concern for the Working Group is this continued indefinite detention, in some instances, incommunicado detention too. This cannot be the way resettlement works. The right to personal liberty and safeguards against arbitrary detention must be fully respected in any such arrangements. Thank you.
Thank you, Alina. Yeah, we hear a lot of reports also at Human Rights Watch that a lot of these so-called rehabilitation centers are really just Guantanamo with window dressing. So what should the US be doing, and what should receiving host countries do to prevent this type of abuse of men who have been resettled from Guantanamo? Where can there be some movement for reform, and What would you like to see happen?
Would you like me to start on this?
Yes. Do you have some thoughts on, you outlined some problems, including the veil of secrecy.
I think
Would, for example, making the documents public help? Should there be a particular monitor? What do you think? What would you recommend? What steps would you recommend the U.S. and receiving countries and the international community take to try to address this problem?
Well, of course, I mean, the question is enormously broad and enormously wide, and there are a lot of things that probably need to be done. But I think as a starting point, everyone, not just in the panel today here and not every people listening in, but equally the rest of the world would like to know what these arrangements are. And I think this veil of secrecy is the number one element. We don't know what these arrangements are. We don't know who is making them, and what the working group found particularly disturbing, that even those who are subjects of these arrangements do not know what arrangements are being made for them. And after the years and years that individuals have spent in detention, to go yet for potentially another unknown is an enormous ask of these individuals. So number one step would be to make things transparent.
Absolutely. Thank you very much. We will turn now back to you, Alka. You have outlined very eloquently the case of your client, Ammar al-Baluchi, who is one of the 5 men at Guantanamo awaiting trial for the 9/11 attacks. These proceedings take place in so-called military commissions that the U.S. set up specifically to prosecute men at Guantanamo. Could you talk to us a little bit about the role of the CIA in these military commission proceedings, and more broadly at Guantanamo? There have been quite a few allegations of meddling. And secondly, and related to that, are these military commissions capable of delivering justice fairly? We have heard from our other expert panelists on this issue, but I'd very much like to hear your point of view as someone there on the front line as well.
Of course, and thank you for the question. You know, I think what people either don't know or tend to forget is that a very deliberate decision was made by the US government after 9/11 when these men were captured, not to prosecute them. They made a decision to hold them incommunicado and try and get more information from them using torture techniques. There was a binary choice there, and they made that choice. And what they're really trying to do now is to have it both ways. The purpose of creating the military commissions down here with their own set of rules and away from the public eye was to be able to hide CIA torture and even use the fruits of that torture to prosecute and eventually execute men without due process here. So, you know, the statement is, my statement is borne out by the CIA's control over, for example, the discovery process. We have fought for a decade, literally 10 years since the charges were filed, to get information about the torture program that we are entitled to in a capital case, and that the government just refuses to turn over. A few years ago, the defendants identified an interpreter in the courtroom as someone who had been in the black sites with them during their period of torture, which, as you can imagine, was incredibly psychologically triggering for them. The men, as I mentioned, lived at Camp 7, a CIA facility, for 15 years, including during the pendency of these proceedings. So the psychological coercion on these men has never ended. The sort of threat of torture has never ended, is never lifted, and that's by design. So the CIA keeps the men quiet. The US government hides them away down here, ties our hands with security clearances over information that's not damaging to national security, but which is embarrassing to the United States. And then tries to use, on the other hand, information gained from their torture to prosecute them. The military commissions are the vehicle by which the US government gets to have it both ways and avoid the scrutiny that would come with federal courts. I just want to say that, you know, we've learned over the last few years that it's really not just the CIA to blame. The corruption at the military commission is a whole government effort to hide the torture program. We know, for example, that the FBI, contrary to their public torture stance, were intimately involved in the torture program through sending interrogation questions to the black sites during the torture and even detailing FBI agents to the black sites. And then the FBI played has continued to play a big role in the cover-up. They've taken torture evidence from the black sites, asked the same interrogation questions over again here at Guantanamo to get answers they could use at the military commission. And I'll tell you, the government has acknowledged that those statements taken by the FBI are the primary evidence against these men in a death penalty case. And the statute, the military commission statute, was written to allow for the use of what they call coerced evidence, a section 948R for anybody who wants to look it up on the website. So you have the CIA, the FBI, the Department of Defense, and 4 successive White Houses working together to keep exploiting a state-sponsored torture program. And at this point, with the decades of corruption and the destruction of the presumption of innocence and the medical state of the men, I don't believe there is a possibility of a fair trial anywhere anymore, and certainly not at Camp Justice. The working group on arbitrary detention, and thank you, Alina, for everything that you have said and your leadership on this. The working group on arbitrary detention came to the same conclusion in several opinions, but in one particular that has impact on us, opinion 89 from 2017 about Mr. Al-Baluchi, my client, and actually called for his release. So, you know, it's a hard truth that we can no longer have a fair trial for 9/11, but it's one that we need to accept as a consequence of the decisions that we made and start figuring out ways to wind down the commissions and recover our legal and ethical bearings.
Thank you, Alka. And I think it's worth reflecting on the fact that these military commissions were actually challenged legally multiple times, and even the Supreme Court decided years ago that they didn't provide due process. So the U.S. revamped the military commissions, but they're still entirely substandard. They're still fundamentally flawed. And what that means is not only is the U.S. denying due process to men who've already been horrifically abused at Guantanamo and often at CIA blacks. Well, actually, all the 9/11 defendants were tortured by the CIA even before getting to Guantanamo, on top of their torture at Guantanamo. But not only are these commissions denying due process to defendants, but they're also depriving victims of 9/11 and any other attacks of justice. So this is, the ripple effect of the violations is vast. So yeah, I'm really glad you're there and continuing to work on this and to try to ensure that the U.S. doesn't get away with this really what are kangaroo courts. Mohamedou, you spoke so eloquently of your ordeal at Guantanamo, and you also touched a bit on what happened to you when upon your return to Mauritania, your homeland. We'd very much like to hear a bit more from you about what it's been like for you since Guantanamo. I take it from your earlier comments that it was initially a rocky path when you got back home. But can you tell us a little bit more about what happened to you on return and how things are now? Because I see that you are now traveling in many parts of the world, which means that there has been some light at the end of the tunnel.
Yeah, thank you, Leta. And I just want to say how much I loved what Alka said, because she's talking about something I know firsthand, like these FBI angels who have their quote unquote clean team. Those people interrogated me. And when I told them, I am going to claim my right as a citizen not to talk to you without you charging me with something, and I'm using that right. And they told me, if you don't, we are going to pass you to people who are not as nice. And I remember what I told them. My English was really bad. I told them, the sooner, the better. I was stupid. And they indeed gave me to this team. And when I was broken, after sustained torture, I think 70, and then I passed out And then there was like about 2 or 3 weeks that I wasn't aware of anything. And then I was just like a floodgate open. I told them everything they wanted to hear, and I confessed. The FBI came with very nice suits. They came talk to me, you know, we don't torture. I said, of course. And then I repeat to them everything that I told under torture, because I know what happens to me if I don't repeat to them this false confession. So I want to be very practical in 2 matters. I want to say, mention the elephant in this room. Why Guantanamo Bay matters so much? I tell you why. First, there is Guantanamo everywhere. I grew up in a military dictatorship, and every prison was Guantanamo Bay. We have Guantanamo Bay now in Ukraine, in Russia, in China, in the Middle East, in Africa, everywhere. But why does Guantanamo Bay matter? I tell you why. Because the United States of America is not only a democracy, but is the hope, is the leader of the free world. And if the leader of the free world act in a fascist manner, saying that certain people don't deserve human rights and certain people deserve human rights, that is the end of our hope for freedom. And I mean, now I look just like America is saying that it's a war crime to invade as an independent country. That's what America does. You know, I don't know what moral ground and also the ally of the United States of America are saying the same. America cannot with straight face tell small countries in Africa or China or Russia that people cannot be held without the rule of law. That's a joke. That's a mockery of human rights, and people understand that. So when I was released, the other practical manner, I want to tell all of those victims to come forward, because 2 things we should need as a victim of torture and kidnapping. First, we should not be afraid. I was afraid. I was very afraid because I was intimidated. They came to me, they said, if you don't stop talking, bad thing going to happen to you. They came and they broke into my apartment in Mauritania. I had no papers. I was not allowed to have even ID card. And I'm a Mauritanian in my own country. But again, I have to reach out to people like you, like the UN, like Human Rights Watch, like Amnesty International, and other organizations to help me. Most detainees, I know they're afraid to reach out. And if they don't reach out and allow people like you to help them, they will not. I allowed people to help me. And I have a big mouth and I'm not afraid. They told me, if you talk, we can show something else. I said, you can show everything you want. I'm not afraid of anything. I didn't do anything. I won everywhere I went with the court. I went with the, in Germany, I went in Mauritania, and I just not afraid. It took me 3 years just to get my passport, end of 2019. And when I got my passport, there is also a very important thing. Those countries in the West, the Western democracy, I'm not talking about dictatorship, authoritarian regime. Those people need to be unseated and replaced by democracy. I'm talking about the free world. They say they are against Guantanamo Bay, but they act as if they are with Guantanamo Bay. They refuse me visa everywhere I went. They look at me, you are in Guantanamo Bay. You're a criminal. We will not give you. I had to hire very good lawyers. And the problem, the tragedy is that I have so much visibility. And with so much visibility, it took me so long just to travel and talk about my story in the Netherlands and in the UK. How about those who don't have visibility? How about those who every day are being intimidated and threatened if they ask for an ID freaking card?
Thank you, Mohamedou. And indeed, this is the big question. It shouldn't have to take lawyers and Human Rights Watch and Amnesty and special rapporteurs and working groups to bring rights to you and other people who have returned home or those who are in third countries. Siobhan, could you please tell us a bit more about how is Mohamedou's experience in his ordeal unique, or indeed, as I well suspect, and as he says, he's hardly the only person in this situation. What happens to men? We've spoken about what happens to men when they're transferred to third countries. What happens to men when they come home?
Yeah, it's absolutely not unique. I think it's emblematic of the individuals that we support and the stories that we hear of individuals being repatriated home as well. Transitions home after repatriation from Guantanamo can be incredibly challenging for several interrelated reasons, and Mohamedou spoke about many of them. For some, repatriation is incredibly dangerous. Their status in the country means they're targeted with further detention, torture, potentially summary execution, and refoulement is a tremendous risk for many individuals formerly detained as well. Another piece of what Mohamedou said is in both categories, in the repatriation context as well as in the resettlement. Even when individuals are going back to their communities, back to their countries, they struggle to get secure legal status, to get residency papers, get passports. And for many, the association of Guantanamo follows them back to their countries. Again, as Mohamedou mentioned, despite Guantanamo detention lacking any due process, despite the extrajudicial nature of what we've discussed, despite the US government saying that the individuals are approving their transfer, saying that they're not a threat, the US government provides no documentation attesting to that fact, attesting to the clearance. And so as a result, it's very challenging for them to reintegrate in society. Men after transfer are often restricted from travel to see family. They're constantly monitored. They find it difficult to gain employment. They require health care for ailments suffered under brutal Guantanamo conditions, and it's challenging for them to access that. And that being said, there are many examples of men formerly detained in Guantanamo who have done extraordinarily well despite these challenges. And Mohamedou is such a good example of that. And for many men, it's helped by, or it would have been helped by, having support from the country to provide safety, security, sustainability post-transfer.
Thank you, Siobhan. It seems to me that it shouldn't be that difficult, really, to provide these basic assurances of humane treatment to men upon their return. And let's not forget that the vast majority of these men have never even been charged for the crime, much less prosecuted, much less fairly prosecuted. And that's not, of course, to suggest that anyone who has been prosecuted should be ill-treated either. But we're really talking about people who've gone through a horrific situation only to encounter another horrific situation once they've returned. I'd like to thank all of you for your comments thus far. And before we move to questions, to pose a question myself, perhaps Fionnuala and Alina would wish to answer this, but any of you really. As some of us have noted at the beginning of this conversation, the line of the US government is generally no prosecution. Let's let bygones be bygones for abuses by the CIA and at Guantanamo. Let's turn the page. Let's move on. Let's not reopen old wounds. What is your response to that? Human Rights Watch and Amnesty certainly are of the view that accountability is essential. But tell us, please, Fionnuala, Alina, others, what you think. Is this critical, and if so, why? And perhaps, Fionnuala, we'll start with you.
Yeah, maybe just to make a concluding comment and observation in this context, I think what we see is the realities of this really ugly chapter, this really sordid chapter of history, which engages so many states, has been handed forward. I think it's really important to know that UN special procedures, and it's represented by Alina and I here today, but actually many of us remain deeply seized in and engaged with this issue and this question. And we do not forget. And if the hope is that we're somehow going to move on and not remain seized of and calling upon the states concerned, particularly the United States, to ensure transparency and accountability, that is not happening. And this is, I think, a fundamental thing that the states concerned must understand. This is not going away because it demands and requires remedy. And I think there are three overarching goals going forward: transparency, return and repatriation, and non-repetition. And so maybe if I could say briefly a couple of words about each of those. In relation to transparency, and Alka is standing right before the Camp Justice flag, we need unhindered access and free access for meaningful fact-finding to these places of detention, not only to address the past practices, but to address the current and ongoing practices, including the finding by special procedures that ongoing torture occurs in the context of Guantanamo Bay, Cuba. And democracies, if they are democracies, have to signal their openness to scrutiny, and they have to show that actually they learned something, that they are able to self-reflect, and that they are able to change how they do, because this is how democracies are supposed to function. And if they don't, fundamentally what that signals, which is I think the comment that Mohamedou made so poignantly, is that the democratic project itself becomes unsustainable when democracies do not learn and do not fix the damage they have done. The second point is on repatriations and return. And I think it's clear persons have to be returned to their countries of nationality, subject to the principle of non-refoulement. And I do want to recognize in this context that the US has made efforts, positive efforts, to clear Guantanamo Bay detainees for release by the PRB and to make arrangements, with all of the caveats and all of the need to ensure the oversight and the clear consistency of those return arrangements with human rights norms. And the resistance we see to ongoing return has to be unstuck. It has to be unstuck, both domestically and internationally. And it's clear we have to ensure that the persons who are repatriated to other countries are not re-victimized. And more than that, that their families are not re-victimized, because it is not only the detainee who's harmed, as Mohamedou has so, again, beautifully articulated and painfully articulated for us, but is their family members who are the victims of this too. And so we need, and we have not had, full redress for any of the victims of torture rendition from this period. And my report contains a full annex of every name of every person we know who was tortured and rendered. And the reason that annex is there is because we have to remember the names. We have to name who was harmed and remedy them precisely as they need and have the right to be remedied. And this is an obligation of states. And a collective failure to do that, I think, leads not only to liability for individual states, but for the broader collective pattern here, reaching the threshold of a core international crime. Thirdly, I want to say, and this is, I suppose, where we have to also focus our efforts, is on the guarantee of non-repetition, to a meaningful commitment to human rights compliant counterterrorism, because counterterrorism has not gone away. And this has to be clear that we do not and cannot engage in these unlawful practices. And we also have to ensure that the kinds of cooperation we continue to see in counterterrorism is subject to full human rights transparency and full human rights oversight. And so the countries who were responsible for this collective failure and facilitated unlawful rendition and unlawful torture are now obligated, in my view, to band together to prevent further abuse. So all of these states, all of these actions are required, and we need a positive, constructive, and deep dialogue among states, civil society, and allies. And most of all, we need not forget. We need to remember, and from that, we need the action that all of the special procedure mechanisms have called for to be implemented.
Thank you. Thank you so much, Fionnuala, for this. And yeah, I think I urge everyone online today to look at this annex and to really reflect on what that means and on the need for accountability. We are out of time. We had several more questions and we have some concluding comments from Simon as well. Simon, I'm going to hand the floor over to you and give you the task of figuring out which of the things we were still hoping to discuss we should, and in what order. Thank you.
Thank you so much, Letta. We've heard today really the extent of the human rights violations at Guantanamo Bay. So I'm just going to quickly summarize and draw us to a close. We've heard about arbitrary detention, we've heard about torture, we've heard about ongoing unfair trials, and we've also heard about the circumvention of justice systems, of how the undermining of the rule of law has occurred not just within the Guantanamo Bay system, but has had global ramifications. I think it's very important that we reflect on the fact that this is an international problem. International ramifications permeate from the Guantanamo Bay detention center. So the question I'd like to ask all of our attendees today really is, what can you do as the international community to end this? The Biden administration has rightly pledged to close the base, but they need to make good that promise. And the international community needs to make sure that the Biden administration make good that promise, but also that those who are currently detained within Guantanamo have somewhere to go. And that means resettling people. But of course, we've also heard today that there are issues with that. It needs to be done in a human rights compliant manner, else there will just simply be a continuation of what Letta described as Guantanamo with window dressing, which I think is a very poignant way of putting it. Finally, I'd like to stress the urgency of this situation. Just because Guantanamo Bay is now in its 20th year, and that's a shocking thought, 20 years of Guantanamo Bay, that does nothing to deplete the urgency of its immediate detention, immediate closure. Guantanamo Bay does not make us safer. It makes us much less safe, as do all other human rights violations. And its continued existence has that continued impact. So to draw us to a close, on behalf of Amnesty International, Human Rights Watch, the International Commission of Jurists and Article 19, I'd like to thank all our panelists today for their pressing and insightful contribution to this discussion. And of course, I'd like to thank our audience for attending. And I very much hope that we're at the beginning of the end of detention at Guantanamo Bay. Thank you all very much.